Okay, hi there, Dr. Matthew J. Trom here. Welcome back from your break. We are in the middle of the intellectual property module discussing patents for engineers. And if this is the first video that you clicked on, I just want to give a quick disclaimer that I'm not a lawyer. This lecture is educational, it's not meant for legal advice. And please, before you make any legal decisions, consult a lawyer before moving ahead with those decisions. So, just as a quick reminder, we were talking about patent infringement and preservation of patents, and we'd gotten all the way through to this slide, which was the cost to file versus a cost to file in addition to preserving patent rights. And remember from the previous slide, we had talked about the fees increasing depending on the size of the organization filing the patents. And so these are the rules that sort of govern where you fall on that cost scale in terms of the size of your organization. So a small entity by USPTO's definition is one that has not yet agreed to assign, license, or otherwise convey the invention in the patent that it's filing to a non-small entity, right? So you can imagine, right? A big company just forms a little company. The little company qualifies as small entity to get out of paying the big fees, and then immediately turns around and hands the patent back to the big company, right? So this small entity provision basically prevents large companies from doing that. So you can't have assigned or plan to assign the intellectual property and the patent to a non-small entity organization. And you either must be a nonprofit organization or have fewer than 500 employees. So if you satisfy those three requirements, then you're considered a small entity according to USPTO, and you're paying sort of at this middle rate here, all the various filing and licensing fees and maintenance fees to maintain your patent. If you're a micro entity, this is basically an individual, right, or really, really small organizations. They have to first meet all of the small entity status requirements, and then they cannot be named as an inventor on more than 4 prior patent applications. And it turns out that patent applications filed with your name on it when you're employed by a previous employer, those are not counted. But if you as an inventor have 4 or more patents, then you can't qualify as a micro entity. Plus, your gross income has to be less than 3 times the U.S. median household income for the preceding year. So, for example, in 2018, the median U.S. household income was $63,179. So 3 times that is about $190,000. So provided your gross income is less than $190,000 and you satisfy these other requirements, you're still a microentity. And then, of course, you cannot have or plan to assign, license, or otherwise grant rights to the invention to an entity with a gross income larger than 3 times the median household income in the United States. And this excludes institutions of higher education, right? So if you are a micro entity, you can pay at the lower rate, and then you can license or hand over your intellectual property to a university or a college, but not to an entity that makes more than $190,000 per year. And then a large entity, well, that's basically everybody else, right? So anybody who's not a small entity or a micro entity is considered a large entity and then has to pay at these highest rates in terms of the maintenance fees. Okay. First to file versus first to invent versus first to disclose. So this is also super interesting and very important for you to be aware of. There's actually 3 different types of kind of patent filing systems that assign rights of ownership to the patent depending on when the invention was conceived and when it was disclosed and when it was actually filed. And it turns out that the U.S. changed from one type of system to another type of system in 2013, which is a relatively recent change, which kind of now changes the way that we have to do a lot of things with respect to the development of technology. So let me just define these for you and then give you a little bit of background. So first to file is the most straightforward one, right? So the first to file file system, FTF just says a patent is granted to the first person to file an application for protection of that invention, regardless of the date of invention, right? So that one is just whoever gets to the patent office first and files the patent, they're the ones who get the invention. That one is super easy and straightforward. Then there is first to invent. And this one gets pretty murky. And up until 2013, the US was actually on a first to invent system. And so for FTI, first to invent, the patent is granted to the first person to both conceive the invention and then also to succeed in reducing the invention to practice. That is, to build a working prototype. Because remember, you can't get a patent unless you can actually describe how this thing works. It actually has to work for you to get a patent. But at least under the US system, the US FTI system, the date of invention is the moment of conception. So provided the person who first conceived the invention is able to eventually reduce it to practice, independently of other potential competitors, then he or she is considered the first inventor. And so under the FTI system, the first inventor is granted the patent even if somebody else files a patent application and or reduces the invention to practice before the inventor. It's not when you file the patent, it's not when you actually make it work, it's when you conceive of the idea and document the idea that sets the moment that the invention was conceived and ultimately who has control of the patent once the appropriate patents are filed. So the reason that this system was just an utter mess is because under FTI, there is no certainty that one is entitled to a patent even after they file a patent and it's been successfully issued, because there's always a risk that an inventor who files a patent later can provoke an interference claim by proving through providing evidence that he or she conceived of the invention before the person who was granted the patent, right? So this is why when you guys take classes, lab classes, we are so adamant about taking meticulous notes in laboratory notebooks, because a researcher's notes in a lab notebook, at least under the FTI system, were evidence in cases, patent law cases, about who was actually the first to conceive and who was the first to invent a particular idea. And so, different potential inventors would bring their lab notebooks to court, and they would say, oh, but I conceived of this here and I conceived of this here. And so what it eventually did was just basically, allow almost anybody to become a patent troll, because, how do you really check that somebody hasn't retroactively gone back and backdated pages in their lab notebook to make the conception date of an invention appear to be earlier than it actually was, right? So there were all kinds of legal arguments and legal battles about who truly was the first to invent and whether these lab notebooks were legitimate or not. So anyway, that's why we make you keep really meticulous lab notebooks in our lab classes, is because of this first to invent rule in the United States with respect to patent law. This system has changed, but of course, before 2019, the U.S. practiced the FTI system. And so USPTO was constantly conducting interference proceedings between rival claimants to review evidence of conception, reduction to practice, and diligence. And by diligence, I mean actually trying to, defend or protect particular types of intellectual property that had later been patented. And then, so it turns out, thank goodness, that the U.S. switched to an FTD, first to disclose system, in 2013, and that is now the system that we operate under. So what is a first to disclose system? Well, a first to disclose system in the US is called first inventor to file. So you might see it referred to as FITF, but I like first to disclose because I think it's more clear. So there are three provisions here. So first is FTD gives a grace period between the initial public disclosure and the patent filing. And in the US, that's a year. It recognizes the person who's first to publicly disclose as the inventor. And it removes disclosures as prior art, which would otherwise invalidate the inventor's patent, right? So those last two are pretty important. In fact, all three of them are important, right? So this gives you the ability to Well, okay, so we'll start with the mechanism of a provisional patent. So if disclosure is made 1 year or less before the effective filing date of a claimed invention, it shall not be prior art to the claimed invention if the disclosure was made by the inventor. Okay, so that's right out of the USPTO statute. What does that mean? Well, it means if you file a provisional patent, if you publicly disclose in a journal paper or a conference presentation, or even just a conversation where there are sort of multiple people there who can witness that you disclosed a new piece of intellectual property, that is the first public disclosure, and you have a year from that date of disclosure to file the patent. Now, what that does also is it excludes everybody else from filing a patent within that first year period, right? Because you've just disclosed, basically put into the public domain this intellectual property. And so number three removes the disclosure as prior art, otherwise invalidating the inventor's patents. Under either of the previous systems, if you had disclosed the intellectual property before you filed the patent, your public disclosure would have invalidated your own patent. But now, under the FTD system, that initial public disclosure, provided you are the inventor who ultimately files the patent, is okay so long as you do it within a year. So you have this sort of year-long grace period between disclosure and the actual filing of the patent, with which to sort of get your ducks in a row and make sure that the patent gets filed. So, as I mentioned, there's a mechanism that USPTO has provided, which is called a provisional patent. So, a provisional patent can be filed with USPTO, or really it can be any other form of public disclosure. And once you make that public disclosure, you have 1 year from the date of first public disclosure in the US to file a patent under the FTD system. Now, this is super important for us in EML 4501 because, as I mentioned before, that poster session that happens at the end of the semester could be argued in a court of law to be a first disclosure of intellectual property. So you have two options. One is you can choose, if you guys have got some new cool invention, you can put it in your posters and you can disclose it publicly at that poster presentation, in which case that's your first public disclosure and the clock starts ticking between that moment and when you have to get your patent filed to get that invention covered. Alternatively, you can choose to not disclose that invention. That is a perfectly reasonable thing to do because this is, potential for public disclosure. So you can choose not to disclose that intellectual property at the poster presentation and keep it sort of closely held for a future time when you do want to make that initial patent filing or first public disclosure through a provisional patent. So that's a little bit of sort of intellectual property patent strategy that you have to work out with your group about how you want to pursue that. And we've had groups in the past do both things. So we've had groups make the poster presentation their first public disclosure, and we've had groups sort of keep the public disclosure for the future by not describing that element of their designs in that poster presentation. Okay, so let's just walk through a couple of kind of examples about the first to disclose system and how it works in terms of the timing. So here's just kind of an arbitrary month in 2015, and we have inventor A and inventor B, who are competing inventors that, as the story goes on, will basically end up inventing independently the same technology and then attempting to get patent protection for that technology. So under this first example, on February 2nd, inventor A conceives of the idea. On February 6th, inventor B conceives of the idea. On the 9th, inventor A discloses the invention, so this is first public disclosure. On the 13th, inventor B files a patent with USPTO, and on the 16th, inventor A files a patent with USPTO. So, take a second to think about this. Under the FTD system, the first to disclose system, who is the rightful owner of this intellectual property? All right. Well, the answer is right here. Since inventor A disclosed first, right, on February 9th, this is their date of disclosure, they receive the patent under FTD, even though inventor B filed the patent application before inventor A did, right? So that's the outcome of that particular example. Now, think about this for a second. What would have happened if we were still under the FTI system, the first to invent system? If we were under the FTI system, well, inventor A, if he or she had documented the invention correctly, would still get the patent, even though he or she had filed later because of the date of conception, which was the 2nd of February, as opposed to inventor B conceiving of it on the 6th. What about FTF, first to file? Well, the answer there is different, right? Because what matters in an FTF system is the filing date, right? So like Europe, for example, is an FTF system, and inventor B would have ended up getting this patent under FTF because they filed on the 13th, whereas the inventor A filed on the 16th, and all of this previous stuff about who conceived what and who disclosed first under an FTF system does not matter. Okay, I've got a second example, but I'm up over my 15-minute limit, so let's stop there. And you guys can take a quick break, and then we will reconvene and walk through this second example.